provided that the motion itself state the purpose of the executive session, and then the rule is also clear that if such a motion is adopted, then during executive session only those matters indicated in the motion can be considered an executive session, and nothing else can be considered an executive session.
Any other comments or debate?
I do have a comment because it's totally missing the entire point here. This is a matter of Debbie Brown's right to constitutional due process of law. She's entitled to a fair hearing. She's entitled to a public hearing if she wants one. Russ Millett got a public hearing. Even our criminals have a constitutional right to a public trial under the United States Constitution. Can we do any less? And as a practical matter, finally, I sent this out as a written email because I strongly believe this. We're going to look incredibly terrible if we try Debbie in a secret proceeding and throw her out. I mean, it's got to be public in order for the Republican Party to retain any credibility, and it's got to be public in order to grant Debbie her right to constitutional due process. She's already got a number of constitutional due process arguments, which were raised by Wayne Ross, but the fact that a complicated complaint was presented on April 4th, and when she was out of town, out of state, and set for hearing on April 8th is a due process violation in itself.
Just to point, that charge will not be heard tonight.
Okay, that's one good decision.
Do you know if Debbie is planning on calling in? I mean,
I do not know.
it would help a lot. I mean, I get what you're saying, and I agree with you, but it would really help too if Debbie could participate.
I do not know whether she plans to call. I do not represent her. I have ascertained that Wayne Ross does not represent her. This is the only thing I've gotten was this communication.
Please speak to the chair. Don't speak to each other.
Through the chair.
Mr. Chairman,
To the committee.
is there
Yes.
anyone here to represent Mrs. Brown?
Is it?
Do we know, Mr. Chairman, if Mrs. Brown has received notice of the meeting?
Mr. Chairman, Rex Shannon.
Wait a minute, can you wait till a minute, Rex, until I'm done?
That is part of the hearing process, but I believe she has. I think there's ample evidence that she has been aware of both the charge and the meeting time and date.
Have members of the executive committee received the communication that she claims to have sent in her email that she was sent to the party attorney?
No, this is good. I'll give you a copy of it.
Yeah.
And you can pass it around, of course.
Mr. Chairman, I'm just, a couple of just questions, but in that regard, I don't recall receiving any email that stated her unavailability for a hearing in April, which is, as she claims. Does anybody say that she has been unavailable for a hearing in April?
Mr. Chairman,
Yes.
she did send an email out, which I believe went to everyone, and I probably got this file somewhere, that she said she would be unavailable back around the 20th of March for a hearing in April, and that she would be available in general, and that she would be available in May. And Mr. Chairman, I have from Robert's Rules of Order, page 656, under removal of officers. Of thus accused has the right to due process, that is, to be informed of the charge given, time to prepare his defense, and appear and defend himself, and be fairly treated.
Does anyone know why? Does anybody know why Debbie Brown isn't in town?
She,
This is Mike Ariane, and I talked to her, last week perhaps, and she said that she was had planned a vacation and to be at the RNC meeting.
The RNC meeting doesn't start until this next Wednesday, and that's
But
the
she
first
said she was
meeting.
going to be planned a vacation.
I think you'll find part of the answer to your question is in the minutes of our last SEC meeting, the very end.
I have, Mr.
Just-
Chairman.
Can I ask a couple of other questions in that regard? But is there any I don't know of any authority where the chairman has the ability to unilaterally rescind a meeting, a duly called meeting of the SEC. Does anyone, Mr. Chairman, does anyone have any reference by what authority she could unilaterally cancel a duly called meeting of the SEC?
As far as I know from the rules, she cannot. When there were 25% or more of the members of the SEC that asked for the meeting, and it was well in excess of 25% of the members of the SEC, asked for a meeting to be held at 5:30 tonight.
Mr. Chairman, her response to that, I looked at that, and the 25% have the right to call a meeting, but I'm not certain that the 25% have the right to set the date of the meeting, because it doesn't say that, and normally the meetings would be set by the chairman.
Well, but in this case, the chairman, who is accused, is not the one who's going to set the date of the meeting. And it fell on
You
my
set the
shoulders.
date of the meeting.
Fell on my shoulders.
I had received an email, I recall, I don't have it with me, that said that she was going to call for a meeting later in April of the SEC, but I haven't received any notice that she has done that. Does anybody know?
What, were you part of the last SEC meeting?
I don't remember if I was or not. It depends on when the last SEC meeting
You were-
It was, I believe, March 2nd.
Yeah.
I believe one of the reasons was.
You're not in the SEC.
No, I'm not.
I'm not recognizing you.
That's fine, but I would.
You're
like
out of
that
order,
to
Mr.
happen
Eastman.
when
Don't force me to ask you to leave
I'm
early.
elected to represent.
Mr. Chairman, if there's one more comment from non-SEC members, I would request that we remove that person from the room, whoever interrupts this meeting. Thank you.
Well, I'm just trying to get at the basic facts here that were presented in the email that our good attorney has brought to my attention, but I'm just a little confused, Mr. Chairman. I'm trying to get squared away so that I understand that. But I guess I would think that a duly called meeting of the SEC where more than 25% of the members asked for the meeting according to the rules, that there would be no unilateral authority on the part of the chair to rescind that meeting. That would be my understanding, and I'm just trying to, if there's something that proves me wrong, I'd like to hear that.
On the contrary, excuse me, through the chair, on the contrary, my understanding is that provision for the SEC to be able to call with a 25% of its membership calling the meeting to call that is for that specific purpose, so that the organization can't be held hostage in performing its duties by a chair. In this case, there was adequate notice sent out, the meeting was legitimately called, and we have a question before us, and there's a motion in front of us, and I think we just need to get on with the business of the agenda today.
To the chair, Rex Shaddick is holding. I just want to remind the chair.
Mr. Shaddick?
I think the points that I wanted to make have been brought up, but reiterating them was the notification went out to the members of the SEC and to the Republican Party chairperson that 25% of the SEC had asked for this, and so I think at that time that's reasonable notification. I think it's time to move on.
Are there any other comments on this debate from people who have not yet spoken?
Mr. Chair? Sorry,
Yes, Mr. Troyanen?
First of all, what is the motion before us? Is it to go into executive session?
Yes.
The motion is to go into executive session for the purpose of this hearing. Is that correct?
Yes, and Mr. Chairman, for a point of clarification, the consideration by the executive committee is required to be in executive session. And, I mean, if the charges want to be brought in open meeting, or if they want to be read, but the deliberation on the part of the executive session is required by the rules to be in executive session, the executive committee. So it is, I guess, merely a restatement of a truism that already exists in my motion, except for the reading of the charges that may be brought against her. And if she has chosen not to appear either in person or telephonically, or to send a representative, then I don't think that there's anything in the public that can be done other than to read the charges and then dismiss into executive session for consideration.
Mr. Balch, this is the chairman. Is it not true that the charges should be kept in the hearing itself?
Well, to be clear, it seems that the issue is the distinction between the hearing and the deliberations of the SEC on the results of the hearing. Now, if one was simply looking at Robert's Rules of Order, both the hearing and the deliberations would be in executive session. However, that is superseded by the rules of the ARP itself, as I read earlier in Article 1, that talks about the requirement under Section 9 and for open meetings and Section 10 for going into executive session. So the effect is that it is within the authority, let me phrase it this way, the default rule is that the meeting of the SEC has to be an open meeting. It is, however, within the authority of the SEC to adopt a motion to go into executive session to deal with personnel matters and with certain other matters. So the governing rule here is that the current motion is in order, that is to say the motion to hold the hearing in executive session. And the separate distinction between the deliberations of the SEC and the hearing is that in the deliberations itself, the accused is not permitted to be present, whereas during the hearing, the accused is permitted to be present. And of course, defense counsel could be present during the hearing. They could not be present during the deliberations unless they were members of the SEC, in which case they could be present.
Okay.
So with that, Mr. Chairman, I would really have no objection to the charges being brought, but without Ms. Brown being here or representation, I don't think anything else could be held in a public part of the meeting.
Through the chair.
Before you speak, Mr. Rent, did you have a comment?
No, I'm okay.
Okay.
Through the chair, Mr. Seekins, I would move to amend your motion to say that we would go into executive session immediately after the reading of the charges.
I would agree to that. I would withdraw my motion, Mr. Chairman, with permission of the second.
Yep, second.
All right.
Mr. Chairman? It's fine.
The chair
It's fine.
recognizes Mrs.
Thank you.
Davis.
It's fine to hold the deliberations confidentially, but you can't just take a complaint and say, here's a complaint, she's guilty. You've got to present some evidence, you have to call witnesses, that all has to be public. You've got to present evidence, you've got to present Mr. Rud, now what would be Mr. Rudrick, I guess Mr. Schulte, to give his testimony on the
Chairman, Rex
complaint.
Daddick.
Mr. Chaddick?
In a previous hearing, we discussed the difference between a board meeting and a courtroom proceeding. I believe Mr. Jacobus is probably confusing his daily life of that which is going on now. That's a executive committee meeting.
No, Mr. Shattuck, I think I know more about this subject than you do. In order to find somebody guilty of a charge, you have to have evidence, and you have to show the evidence. Here you're saying...
Mr. Chairman,
I was talking and he interrupted me. We're shutting
representing
up.
the party that's arguing with members of the SEC.
I think he's trying to give us his best advice.
I'm trying to pass the legal advice, yeah.
His best advice, Mr. Chairman, is...
Then I would ask that he be a little bit more civil and not so full of rhetoric.
Hey, you're the guy who interrupted me.
Okay, now.
Oh, I can take care of that.
Mr. Seekins, did you wish to restate your motion?
Well, with the previous motion has been
Withdrawn.
withdrawn. Mr. Chairman, I would move to commence with the reading of the charges and any presentation of the evidence, and open for defense by Mrs. Brown or her representative, and then to convene in executive session for deliberation.
Second, Steve Street.
I don't know if it's that simple,
I understand.
okay, because there's a pro and a con and a pro and con. It goes back and forth for a period of time.
And, Mr. Chairman, I understand that, and I think if Mrs. Brown has chosen not to defend herself, I don't think that that is an adequate reason for us not to continue the hearing to be able to determine whether there's legitimate charges or any legitimate action to come from the charges.
Mr. Chairman, if I may,
Yes.
as the author of this complaint, I certainly have no problem reading charges openly. I think, for all the people who are here that are interested, I think that's appropriate.
So as I understand what your motion is to do everything short of the deliberation in open meeting.
Yes, I'd like to hear the charges and any evidence of the charges, and then allow someone who is authorized on Ms. Brown's part, or Mrs. Brown, who has the ability to be able to appear telephonically, even on vacation, to be able to present a defense so that we can deliberate.
Somebody pass this down to him, just so I know what we're doing together.
Mr. Chairman, the parliamentarian.
Yes, I'm now passing to Mr. Seekins. Mr. Balch, the procedural suggestion that you had.
Yes, and if I could just make a quick point on the proposed motion. As I understand it, it's stated as saying that everything except the deliberations would be an open meeting. Actually, one does not need to adopt a motion to do that, since the default is that everything except the deliberations would be in open session. What would happen is, at the time that deliberation was going to occur, that then a motion would be adopted to go into executive session for that purpose.
Correct. And Mr. Chairman, if I could, looking at Article 1, Section 9, that all official meetings of the ARP Division should be open to all registered Republicans. Mr. Chairman, I would read that to mean that it's only open to registered Republicans. And I would request the enforcement of Article 1, Section 9, to make sure that no one participating in or viewing this particular hearing is not a registered Republican.
How do we verify that?
I think we'd have to find a way.
We could start with the honor system and just ask.
Or a voter registration card?
I don't believe anything that's being publicly telecast can be restricted only to registered Republicans, Mr. Chairman. There's a camera that's operating directly behind you.
There's a motion on the floor.
All right.
You want to restate that motion again?
Well, the motion is made, but then I would like to enforce.
All right, so you have two
Article 1, Section
motions.
9. Well, let's pass the first motion.
Okay, so the first motion is to keep the meeting open up until the point in the procedures of deliberations.
Correct.
Okay. Is there a second?
There was a second, Steve.
Steve Streets.
Mr. Chairman, parliamentarian.
Yes, Mr. Balch?
Yeah, in my professional opinion, that motion would be technically out of order, because the problem is that the default ruling is that it is an open session. So if you were, suppose you were to defeat the motion that says it will be an open session, then that would leave ambiguous the question of whether or not you are voting not to hold it in open session or to hold it in open session. So respectfully, I would suggest that if I understand correctly the intent of the motion, namely just to go into executive session when deliberations occur, that the motion should be phrased in the way of not saying that there will be an open meeting until then, but simply say that when deliberations occur, the meeting will go into executive session to consider personnel matters.
Mr. Chairman, I've revised my motion that the meeting be an open meeting until such time as we go into deliberations, and that it be executive session at that time for the purpose of personnel matters.
It's acceptable in a second.
Does that sound right, Mr. Balch?
If you strike out that it be an open meeting, then it would be fine. It will be an open meeting. You just don't say that in the motion. You just say that in the motion that when the SEC goes into deliberations, then it will be held in executive session for the purpose of personnel matters.
The Secretary will make those corrections for me.
Okay, so the motion on the floor is to go into executive session when the hearings reach the deliberation stage.
For the purpose of personnel matters.
For the purpose of personnel matters.
That's
Okay,
correct. Second.
and we have a second. Okay, debate, any further debate on that issue?
Madam Chair, just a point of
Chairman?
information.
Mr. Chair, please.
Madam Chairman, sorry about that. Well,
Mr. Chairman.
Mr. Vice Chairman, I suppose, or Mr.
He's chairing the.
Whatever,
Exactly.
chair, I don't care, just call me mister.
The point I wanted to make is that, yeah, this is procedurally correct. And except I would say more than personnel matters. I would say that it's going into executive session for the purpose of making a decision on the Debbie Brown complaint.
All right, are you offering an amendment?
No, I can't, because I'm a non-voting.
That's right, you're not a member, okay, but you're ready to speak. Any further discussion on this motion?
Mr. Chairman, this is Mike Ariani.
Yes, the chair recognizes Mr. Toriani.
Do we have more than one motion on the floor?
No, we do not, we only have the one motion.
Thank you.
Any other comment on that one motion? Okay, the motion on the floor is to go into executive session for the purpose of deliberation.
At the point of deliberation.
At the point of deliberation
For personnel matters.
for personnel matters. All in favor of the motion signify by saying aye.
Aye.
All opposed? All right.
Mr. Chairman,
That motion carried.
I would ask as a point of, I ask you to rule, Mr. Chairman, that we enforce Article 1, Section 9 of the Open Meetings rule of the Alaska Republican Party rules that says that all official meetings in its subdivision should be open to all registered Republicans, and that those who are not registered Republicans not be in attendance. Either personally.
I agree with that.
You're gonna have to remove the camera. You can stay.
This is for the secretary's
This
reporting,
was
actually.
Ralph Stevens.
No, this is the secretary today.
I'm okay with her recording, doing this just for me. I'm not okay with
Yeah, but
sending it
you're
out
live
to
streaming it,
others.
aren't you?
No, this camera can't live stream at all.
Doesn't make sense.
Back to the motion. Or the rule. Is that a motion or just a rule?
It was a ruling.
Okay.
Turn the camera off.
Just as a side note, on executive meetings, essentially no recording.
No.
No